Well, good evening, everyone, and welcome to AJ103 Criminal Evidence Online. And tonight's lecture is going to be on Chapter 13, where we are going to look at plain view, consent, vehicle, and administrative searches. And as in previous chapters, we do have a lot of information to go through. And this chapter, we're going to kind of jump around a little bit, so bear with me as we move around and look at the various subjects that are contained within the chapter. Don't forget about your student resources, the key terms at the beginning, and the discussion questions at the end of the chapter. And also take the time again to look at the examples that are listed in your textbook as well. So with that being said, let's jump into our featured case. Now, Detroit Lion running back Michael LaSure was stopped twice while driving and cited for possession of marijuana. And in the first stop, the drug was found during a consent search. But during the second stop, the officer smelled marijuana and the police dog alerted to it. So in each of these cases, the officers came into contact with LaSure while he was on a public highway. So as we look at the case, and it's only about 2 pages, so you can read the case, when you're done, let's ask yourself these questions and run them through your mind. What rules for searches should apply to cars? Should we allow to just stop a car and search it because it's a car, because it's mobile, because it could carry evidence? Should it matter why a traffic stop was made? Does the means for the stop, a citation or criminal activity, present a different rationale to search further in a vehicle? And what parts of the car should be open for search, if any? So kind of mull those questions through after you're done reading the case study. And again, it's pretty short, so it won't take you very long to get through it. So what do we want to learn in this chapter? Well, explain what we call the plain view doctrine and define the open fields doctrine and describe the right to search abandoned property and what are consent searches. And what about distinguish vehicle searches and Terry stops, and explain how searches are conducted when you impound a car. Explain when searches are and are not necessary. And identify situations where administrative warrants might be helpful or appropriate. So when we look at some myths and facts, let's just kind of think about these as we go through, and then we'll jump into our lecture further. So under the plain view doctrine, an officer can seize anything in plain view when a search is conducted. Well, yes, but no. So there's going to be some factors that have to apply as it relates to plain view, and one is that the officer must be legally at the location. And if that part is there, then we also still have to have probable cause that the items are contraband or evidence. Well, what about evidence officers find while trespassing, let's say in an open field? That's not admissible in court. Well, based on the open fields doctrine, evidence is admissible even if the officer were in fact trespassing. Well, another one, police must tell people or warn them of their Fourth Amendment rights prior to asking for consent to search, let's say, their car or a backpack or whatever. And I'll just say it like this: nope. Only the owner of a building can give valid consent for the police to search without a warrant. Well, not really. Anyone with apparent authority can give consent for an area. And police must obtain a warrant to search a car unless there's an emergency. Well, no, remember what we need to search or arrest? It's probable cause. So if police have probable cause, they can search a car without a warrant. And then police are allowed to search a car only if they believe the car is being used for illegal activity. Well, not especially, because there are a lot of other exceptions that are going to come into play, and we'll talk about some. So plain view. The plain view doctrine established in Washington v. Chrisman and Coolidge versus New Hampshire and other cases is one of the most well-known and useful exceptions to the warrant requirement. And if we were to look at this a little bit further under plain view, it's not an unreasonable search for officers who are legally on the premises to observe items left where they can be seen. But along with that, they are going to need probable cause in order to seize the objects that are in plain view. So again, the officer has to be at a location where they're allowed to be. So it's not it is not an unreasonable search for officers who are legally at a place and they see these items in plain view and they're legally there, but you still have to have the other piece. You still have to have probable cause in order to seize those items. So let's define this plain view doctrine. And the plain view doctrine has three key elements. The first is that the officers are legally at a location where the observation was made. And the second is that the object can be seen without a search or something they call disturbance. And I'll get a little more into that later, but it means like moving the object. And then finally, probable cause exists to seize the object. So those are the three key elements. Now, for the plain view doctrine to operate, the officers must be legally at the location where the observation is made. We know that. And probably the most common situations involve making arrests, conducting field interviews, stopping cars for search, and executing search warrants. And if the officer illegally entered the house, for example, nothing observed inside would qualify for that plain view doctrine. So again, for the plain view doctrine to operate, you have to be legally at the location. And we talked about those instances that were probably the most common. And if we're at this place or we enter this house illegally, then that plain view doctrine is not going to apply. So hopefully that kind of makes sense. Now, here's one of those cases. This is Coolidge versus New Hampshire. Now, the police here were investigating the murder of a teenage girl, and the Attorney General of New Hampshire acted as a justice of the peace, or acting as a justice of the peace, issued a warrant allowing the police to search Coolidge's car. Now, part of the warrant process here, or what the courts say, is that warrants have to be issued by a neutral judicial official, not prosecutors. So the state still sought to admit the search based on incident to arrest, plain view, and what we're going to talk about later, this thing called the automobile exception. So while the court took issue with the fact that the warrant was issued by somebody, or a justice, if you will, that was kind of involved, the state still sought to admit the search on a couple of other instances, which would be incident to arrest. And I think we've talked about that. In plain view, which is what we're talking about now, and the automobile exception. So we'll hit the highlights on those in a minute. So when we apply this law to the case, in Coolidge, the court struck down the search warrant because of who issued it. So the court took issue about the fact that, you know what, the justice that was basically prosecuting the case was also the one that issued the warrant, and he can't do that. And is it important that what official issues a warrant? Is it important which official does, especially as just one side typically presents evidence? And should the courts create a unique body of law for searching cars? And what about schools or homes or businesses? And should there be just like one standard, or should there be like a whole bunch? And you'll see that there are a lot of different standards for searches. So here's another one. So we talked about plain view for a moment. Let's talk about aerial searches. So aerial searches are an extension of this concept, if you will. And in California versus Seraglio, the Supreme Court held that observations made from a police aircraft, they qualify for the plain view doctrine. And the fact that the defendant built a fence around his backyard indicated a subjective expectation of privacy, but the court found that this did not matter when police observed some marijuana plants with the naked eye from public airspace. And since this case arose from observations made from a chartered aircraft, it is clear that the observation does not have to be made during routine patrol or from a frequently used flight path. So again, aerial searches are an extension of kind of the plain view doctrine. And the case that's being cited is the California versus Seraglio case. And I think it is right here. So again, Mr. Seraglio was growing marijuana in his backyard, but it wasn't visible, or it was invisible from the ground because of a large fence. Now the police used planes flying at over 1,000 feet to kind of look down at his property with the naked eye. And using what they saw, police got a warrant to search his property. And the Supreme Court agreed that, you know what, this search is valid and there was no need for a warrant if flying over property. Well, what about a very interesting case? And a lot of these are super interesting, and we'll move on. And this is the Kylo versus United States case. And it covers thermal imaging. And I want to see if this will actually pull up. And if it does, great. And if it doesn't, then I'll be sad. Okay, so it sort of cuts off, but that's okay because we just need the meat here. So here's the facts of the case. A Department of Interior agent suspicious that Danny Kylo was growing marijuana used a thermal imaging device to scan his triplex. And the imaging was used to determine if the amount of heat emanating from the home was consistent with high-intensity lamps typically used for indoor marijuana grows. Now, subsequently, the imaging revealed that there were relatively hot areas that existed compared to the rest of the house. And based on informants' utility bills and the thermal imaging, a federal judge issued a warrant to search the home. And the search unveiled marijuana. And after Kylo was indicted on a federal drug charge, he unsuccessfully moved to suppress the evidence seized from his home and then entered a conditional guilty plea. Now, ultimately affirming, the Court of Appeals held that Kylo had shown no subjective expectation of privacy because he made no attempt to conceal the heat escaping from his home, etc. And if he had, there was no, again, objective, reasonable expectation of privacy because the imager did not expose any intimate details of Kylo's life, or etc. So the question here is, does the use of a thermal imaging device to detect relative amounts of heat from a private home constitute an unconstitutional search? in violation of the Fourth Amendment. And here, it was yes, it does, in a 5-4 opinion by the Supreme Court, and I'll let you read the opinion later. But these are just cases that you can look at that are going to be significant as we talk about what we're talking about today. So thermal imaging devices, you can use them outside to track footprints or heat footprints and handprints and things like that. But if you're going to aim them at somebody's house for the mere fact to use them for detection like this person did, it was deemed inappropriate. So we talked already a little bit about the plain view. So now let's talk about observation. So we talked, remember there's those key 3 elements. One was, legally on the premises. Well, now let's look at like observation. So finding objects in plain view is not considered a search because they're not hidden. However, under the plain view doctrine, officers are not allowed to move things or otherwise examine them for identifying marks like serial numbers. So the item must be at a location where the officer can see it without disturbing it. And this does not prevent the officer from themselves moving to a better vantage point to observe the item, like, for example, walking around the room, stretching or bending, as long as the officer stays in the area where he or she is legally entitled to be. And most courts also allow officers to use like flashlights and even binoculars. So for example, in the feature case that we talked about, the plain view doctrine applied when the officer approached the passenger side of the SUV and smelled marijuana. It also applied to the small pieces of marijuana the officer saw on the front of LeSure's shirt. And the chunks of marijuana that LeSure was chewing, well, those were not covered by the plain view doctrine because they became visible only after the officer ordered him to spit them out. So kind of interesting way that this works. And also in Horton versus California, the Supreme Court made it clear that items do not have to be discovered inadvertently to qualify for the plain view doctrine. Now in that case, officers requested a warrant to search for stolen property and weapons. But the judge issued a warrant authorizing only a search for stolen property. Now, while executing the search warrant, the officers did not find any stolen property, but they did find weapons. And the court held that these weapons were in plain view and legally seized, even though the officers suspected that they were there before going to the location. So there are some other examples of observations that are on page 384. So a quick review. Finding objects in plain view is not considered a search because they are not hidden. However, officers, they're not allowed to move things. They can bend around it and shine their flashlight to look at the serial number or things like that, but they can't pick it up and spin it around, etc. So the item must be in a location where the officer can see it without disturbing it. And again, this doesn't prevent the officer from moving to get a better vantage point. Flashlights and things like that are okay. And it need not be an accidental discovery. And if you're at a location or you're serving a search warrant, and let's say the search warrant is for narcotics, and as you're searching, you find other items like stolen property, those are applicable. You can seize those items as well. So just to kind of, keep things going as it relates to those, items in plain view. So here's the Horton versus California case. And we kind of talked about this one at length, so I could probably skip past it. Well, what about probable cause to seize? So we've gone through point 1, legally at the location. Point 2, objects must be where officers can see them or observe them. And point 3 is probable cause. Well, the fact that an item was in plain view and the officers were legally present indicates that there has been no unreasonable search so far. Now, the final issue deals with the right to seize the item. So to do this, there must be probable cause, and there's a case, Arizona versus Hicks. Now, reasonable suspicion, we know, is not enough. Remember, that's the level, the standard lower than probable cause. And this probable cause requirement means the facts must indicate it is more likely than not that the item is evidence of a crime or is contraband. And this decision must be made without searching the item for clues like serial numbers, unless you can see them. And if probable cause exists, the item can be seized on the spot without a warrant. Even when the facts do not establish probable cause, the observation may still be useful. It may provide leads in the investigation. And the observation can also be included along with other facts in an affidavit used to obtain a search warrant to conduct a full search of the location. So if you're there lawfully and you see things, but maybe you don't have probable cause to believe that they're contraband, etc., but it might help you further a different case or some things additional to that case, and you can reach that level of probable cause on, say, a different type of crime or something else. You can use that stuff you saw to add to your affidavit, to your search warrant, to go back and get a search warrant and then come back and investigate that or search that house, etc. Does that kind of make sense? I hope it does. So again, probable cause have to be in the location lawfully, or consent, okay, or public property, and probable cause to seize. Well, you can't seize simply because we suspect a crime. If not probable cause, we may be able to still use the discovery to continue an investigation and use that discovery to get a search warrant if you don't have one already. And there are some examples of probable cause on page 385. So remember, the fact that the item was in plain view and the officers were legally present indicates that there has been no unreasonable search. And the final issue, like we talked about, dealt with that fact of the right to seize. And to do this, there must be probable cause, because reasonable suspicion, we know it's not enough. We need to have more. Well, what about things that are like open? When we talked about houses and things, what about like open fields? Kind of like in the case where the officers flew over. Well, the open fields doctrine, so you can see the different definitions that we're going past, and that's probably why I keep telling you to go through those key terms, because you'll see those in there. The open fields doctrine, established in Oliver versus United States and United States versus Dunn, relies heavily on history and the wording of the Fourth Amendment. Now, since farmland and other open spaces are not included in persons, houses, papers, and effects that are specified in the Fourth Amendment, they're not protected. And historical protection of what we call the curtilage, and I'll explain what that is in a minute, or enclosed area immediately around a house, like the fenced area, etc., expands the amendment to those areas, but not beyond that to open fields. And there's a diagram on page 386 in your textbook that talks more about that, and I think I have it. But again, the open fields doctrine was established under two cases, Oliver versus U.S. and U.S. versus Dunn. And in that Fourth Amendment, if you want to read it again, you don't see open, farmland and open fields, etc. in there. And this open fields doctrine says that evidence found by officers in the open areas that are not close to homes or in that curtilage, if you will, can be seized. And this evidence is admissible even if the officers were trespassing at the time that they seized it. So we have a little bit of leeway. So let's take a look here. So here's the home, and the curtilage I was talking about, it'd be like the fence. So in this example, so the imaginary line going through here, the fence, this is the curtilage of a home, and this would be considered not admissible. Okay, but outside of that curtilage here, even if you had a no trespassing sign, outside of this curtilage, evidence found there would in fact be admissible. And you could search that as well. So officers can go through here searching. They just can't go inside the curtilage. Make sense? And I hope it does. And the diagrams typically help. Well, what about abandoned property? What if you like throw it while you're running or something like that? You see it on TV where somebody chucks a backpack. So one of the key points in the Supreme Court's analysis of search and seizure issues is the expectation of privacy, and both an objective and subjective expectation of privacy must exist. Now, the subjective part of the analysis focuses on the efforts of a person to protect his or her privacy, the efforts that they took to protect their privacy. And the objective aspect of privacy means that a privacy interest exists that society is willing to protect. So seizing abandoned property is not an unreasonable search because there is neither an objective nor a subjective expectation of privacy. Remember, you go back to subjective, the effort someone took to protect their privacy. Well, if they're running and they throw a backpack, that's not much of an effort to protect the privacy of the backpack. And even if you looked at objective, means the privacy interest exists that society is willing to protect. Well, society says, hey, if you got rid of it, if you didn't want it anymore, then you basically discarded it. So the courts say because there's no objective or subjective expectation of privacy, it's abandoned. You just got rid of it. Now, in most cases, the fact that the property has been abandoned clearly indicates that the previous owner or person in possession of it no longer has any interest in it. And this is clear when the property has been left in a public place, and it's typically more clear when it happens there. The more difficult question arises when we're talking about things like trash that has been sealed in like opaque plastic bags, those trash bags, and you leave them at the curb for pickup by the garbage truck. And although the opaque plastic may indicate a subjective expectation of privacy, so people can't see like everything, and you're trying to protect like your garbage so people don't like look and see all the weird stuff you have, the Supreme Court in California versus Greenwood said that, you know what, there's no objective basis for this expectation. And this rests on the fact that strangers, animals, and other people kind of go through your trash. So the person throwing out the trash has no authority to prevent the garbage collectors from rummaging through it or giving it to the police. And items left for recycling result in the same conclusion because it should be anticipated that someone might sort through them as well. So the final factual question is whether something has been abandoned. tossing something into a trash can in a public place or littering on a highway are pretty obvious examples of somebody throwing something away or abandoning it. Now, a person who merely puts an item, let's say in their wastebasket inside their house, well, you can still go to that basket and take it out. And people have done that before, so therefore there is an expectation of privacy. So again, abandoned property, owners abandon property when they deny ownership or leave it without intent to exert control of it later. And property that is abandoned has no expectation of privacy and may be searched and seized without a warrant. And we talked about the difficult question that comes up about people taking their trash to the curb. Well, we learned now that the Supreme Court in California versus Greenwood ruled that there is no objective basis for this expectation of privacy. So, too bad, I guess is the best way to put it. Well, what about consent? How about when people say, hey, an officer might say, can I search your car? And you go, sure, go ahead. Is that all you have to say? Or is there more to consent? So consent must be given by someone with apparent authority over the area to be searched. And that's found in United States versus Matlock and Illinois versus Rodriguez. And officers may rely on reasonable appearances that a person lives at a house or owns a business. And ownership, however, it's not really essential. In fact, the owner may or may not be able to consent. The key is reasonable expectation of privacy. And landlords cannot consent to searches of a tenant's apartment, contrary to what people think. Nor can a hotel person grant permission to search a person's guest room. That's another myth. And police cannot rely on consent from people whose personal privacy is not at stake. So let's say if two people have equal right to a location, either may consent to a search. And this commonly applies to husband-wife or roommate situations. So for example, either roommate can consent to the search of a kitchen. But if they have separate bedrooms, one cannot consent to the search of the other one's room. Now that rule changes if one of the individuals with a privacy interest has explicitly refused to give consent for the search. And when this occurs, officers cannot rely on the consent of the other occupant even though they have an equal interest. And that was a case called Georgia versus Randolph. So there are some other things that we'll talk about as well. The parent-child relationship, that's a little more complicated. If a young child is living at home, the parent can consent to a search of the child's room and possessions. Older children, however, may have their own privacy interests. And paying rent, or the fact that the parents recognize the child's right to exclude them from the room, may indicate that a parent cannot give consent. So a lot of ins and outs. So consent searches, officers don't need a warrant, first of all, if they have consent. Now, on the other hand, probable cause to search cannot be based solely on the fact that a person refused to give consent. And I'll explain why. So what is consent, I guess? Well, consent is when a party with ownership or control allows access or search of property. And they must have authority to consent. And we typically look at the standard for consent and ask who can give consent. And we examine what limits have been placed on consent as well. So backing up a little bit, consent is defined as a search conducted based on the voluntary consent of a person with apparent authority. And there are three key points. Let me back up so we can make sure that we get all this. There are three key points that have to be considered to determine if a search can be based on consent. One is the standard for obtaining consent. And the next one is who can give consent. And the last one is what can be searched based on the consent given. And in a case called Cloth, that's a tough one, versus Bustamante, that established that consent searches must be given voluntarily, and this is a big thing here. The Supreme Court has, however, specifically refused to require officers to warn suspects that there is a constitutional right to refuse to give consent for a search. So therefore, each case must be analyzed on the totality of circumstances that were present when the officer asked permission to search. So what we're saying here is that these are the key issues, okay, when considering whether or not someone has the authority to consent. And we don't have to, law enforcement, they don't have to warn someone. If they ask for consent to search, you don't have to tell them, hey, by the way, you don't have to consent to search if you don't want to, and here's why. You just have to have the consent be voluntary, as was expressed in that case law. Now, consent may also be implied from a person's conduct. It's well known that everyone goes through a security check before, when you go to the airport, or sometimes being admitted to a rock concert. Therefore, consent is implied when a person gets to the checkpoint. Now, on the other hand, a person who turns to leave is showing that he or she does not want to consent. And consent is not voluntary if the police inform someone that they have a search warrant in order to basically convince them to open a door. Allowing the police to enter in these circumstances is considered to be merely acquiescing to authority. And by stating that they have a warrant, the police have in effect informed people that they do not have the right to refuse entry. More commonly, the courts will consider all of the facts present when a request is made for consent. And the fact that officers had their guns drawn might weigh heavily against consent being voluntarily, right? And other applicable factors include the education and intelligence of a suspect, or attempts made by police to intimidate the suspect, and the fact that the suspect already knew his or her rights. So kind of keep all of that information in as we're talking about consent. So we talked about this standard of consent, and I gave you the case law that corresponds with it. So the U.S. Supreme Court, remember again, specified that we're not requiring officers to warn people that there's a constitutional right to refuse. And we know consent now can be implied by someone's actions. And consent is invalid if, in fact, the police lie about it. And that standard of consent, the courts will consider all the facts present when the request for consent was made. And the example that I use here is the officers that had their guns drawn when they asked for consent. So who then can consent? We know what consent is, and we've talked a little bit about the standard for consent. So who can do it? Well, consent must be given by someone with what we call apparent authority, over the area to be searched. And again, officers may rely on reasonable appearances that a person lives at a house and or owns a business. And we know ownership isn't essential. In fact, the owner may not be able to consent at all. So let's kind of go down the list and we'll talk about these quickly. So consent must be given by someone with apparent authority. Party with the expectation of privacy. And if two parties, either person may consent. And for the most part, parents may consent for the minor. However, children, they can't consent to search. And we also know that parolees and those on probation may be required to consent as a condition or a precondition of their release. So these are just kind of a laundry list, if you will, of those who can and maybe cannot consent. And there are some more examples on page 392. So what about the scope of the search as it relates to consent searches? Meaning, how far can we search? Well, the area to be searched and how long officers can search may be very broad, or it may be limited. And these factors are going to be governed by the conditions that are accompanied with the consent. So whoever consents kind of sets the conditions for the search. And once consent has been given, officers can search anything in that area, including closed containers, unless, of course, the person giving the consent has put some restrictions on what you're allowed to search. And to go along with that, consent can be withdrawn at any time for absolutely no reason. So if they give consent, you can start searching, and if they say, well, I changed my mind, you have to stop. And if the scope of the search is you can search everything here, but you can't search that safe right there, then that's all you're allowed to do. And if something is discovered, though, during the scope of that consent search, it could actually widen into probable cause. So what is found during the search may create probable cause for an additional search. And if so, this probable cause can be considered by some officers when seeking a search warrant. It may also indicate that some other exception to the warrant requirement might apply. Now, the plain view accompanies a consent search. So think about it. Anything seen during the consent search can be seized if there's probable cause to tie it with a crime. So you can see how some of these things are kind of woven together, if you will. Well, how about vehicle searches? Well, cars and other vehicles are considered highly visible and highly regulated, and their extensive exposure to public view, coupled with detailed licensing requirements and safety inspections, has resulted in a lesser expectation of privacy in vehicles than houses, actually. And the mobility of vehicles is viewed as creating urgency, not present when evidence is found in buildings. So for all these reasons, the rules for searching vehicles are somewhat different than those for other locations. So let's talk about vehicle searches incident to a lawful arrest. So when a person is in a vehicle at the time of arrest, the officer's authority to search the vehicle depends on the specific facts of the case. And the same standard applies to recent occupants of the vehicle, such as a man who saw the police car approaching and quickly got out of the car and started walking away from it. That's Thornton versus United States. That's kind of an interesting case. The right to search a vehicle incident to an arrest applies only if there is a custodial arrest. So you have to remember that. If a person is released at the scene with a ticket, the officer's right to search is judged based on the Terry rules, or the Terry versus Ohio case. So again, if you arrest any occupant, driver, or passenger, you can search those areas where they were seated in. And even what we call recent occupants, like someone that you see get out of a car and perhaps start walking away from a vehicle. Now, in 2009, the Supreme Court clarified the law on this type of search by stating that officers may search the passenger compartment of a vehicle if they have reasonable belief that a person being arrested has access to the vehicle at the same time of the search. And this rule does not apply if the person has been handcuffed and placed into a police car or removed from the scene prior to the search. And the second rationale for a search at the time of an arrest is that the vehicle contains evidence of the crime for which the occupant was just arrested. And if the facts indicate that this is true, the passenger compartment may be searched. And other situations that we're going to talk about later, like an inventory search, is also going to be proper as well. So, searches of cars with probable cause, the scope of the search is tied to the nature of the probable cause. And the search is restricted to the areas where there is probable cause to believe those items are at. And the search can include weapons for police safety. And there are really no time limits, and the search can be very extensive and complete. Well, what about that inventory search? We talked a little bit about, the incident to arrest. What about inventory searches or impounded vehicles? Well, let me throw in one thing really quick when we talk about searches based on probable cause. And that would be here. Now remember, as we back up, we talked about searches in cars incident to a lawful arrest. And then we talked here about searches of cars with probable cause. So I think we got that covered. Well, what about inventory? Well, whenever a car is legally impounded, it may be inventory. So a vehicle may be impounded when the driver is arrested. And the police may search impounded vehicles. And it's generally to make an inventory for protection of the officer and the suspect's property. So as I stated, whenever a car is legally impounded, it may be inventoried. And the reason for impounding the vehicle has no bearing on the right to inventory. The Supreme Court in South Dakota versus Opperman stated that based on the right to conduct the inventory on the protection of both the owner of the vehicle and the police. And the police protect the owner by accounting for everything that is present, and maybe even removing items that are valuable that could be stolen. And the police are protected against unfounded claims of theft because a detailed report is available stating exactly what was in the vehicle at the time it was taken into custody. So, generally, less evasive than searches for evidence to a crime, but we have the right to inventory vehicles. So the police may search or inventory impounded vehicles. Now let's look at vehicle searches based on reasonable suspicion. We talked about probable cause already. But what about this reasonable suspicion? Well, the Michigan versus Long case stated that two prerequisites for the search of a car for weapons. And again, the first is you must have articulable facts that cause the officers to believe that one person was involved in criminal activity, and that you must have at least reasonable suspicion that the vehicle contained weapons the suspects might use against the officers. And here's the Michigan versus Long case. So Long ran his car off the road, and police arrived and found him acting really strange. So they searched him, and inside of the car they found marijuana. Now they conducted a protective search, if you will, of the trunk and found 75 pounds of marijuana. And the court found that there are two prerequisites for reasonable suspicion for a search. And one is articulable facts that lead an officer to believe the party is engaged in a crime. And the second is reasonable suspicion there may be, in fact, be a firearm or a weapon. So in the Long decision, the Supreme Court focused on different standards for federal and state searches. So for you to think about, should federal law be a floor or minimum, or a ceiling, your maximum as far as rights go? And why should basic rights vary between states? Well, what about searches outside of a car? And is that even like a search? What if the car was involved in, let's say, an accident, and you wanted to perhaps take paint chips off of it or something? Well, the outside of a car parked in a public place falls under the plain view doctrine. And what is seen may be used to establish probable cause for further action. And in one particular case, Illinois versus Gabales, police dogs may sniff the exterior of a vehicle that has been legally stopped and continue on their investigation. As a matter of fact, we're running at a pretty decent amount of time, so let me click on it and let's look at it. So this is Illinois versus Cabales. Now I know it's not centered, but let's look at the facts of the case and let's see how you do. So during a routine traffic stop, and I'm reading right here under facts, a drug detection dog alerted police to marijuana in Mr. Cabales' car trunk. Now an Illinois court convicted Cabales of cannabis tracking, marijuana. And Cabales appealed and argued that the search violated his Fourth Amendment right to be free from unreasonable searches and seizures. Now the state appellate court affirmed the conviction. Well, the Illinois Supreme Court reversed and ruled that police performed the canine sniff without specific and articulable facts to support its use, unjustifiably enlarging the scope of a routine traffic stop into what they called a drug investigation. So the question is, does the Fourth Amendment search and seizure clause require a reasonable, articulable suspicion to conduct a canine sniff during a traffic stop? Well, what do you think? Well, let's look. So Justice John Paul Stevens delivered the court's opinion that Cabales' Fourth Amendment rights were not violated. Now the Constitution, and they go on by saying the Constitution did not require police to have reasonable suspicion to use a drug detecting dog on a car during a legal stop. And no legitimate privacy was at risk, the court argued, because the dog only alerted to the illegal drug. So kind of interesting. So what they're saying here is that police dogs may sniff the outside of a car that has been legally stopped. So an interesting case. And then there's vehicle searches for non-criminal investigation. So few cases point concerning these types of searches, and they're mostly community caretaking type functions. And basically, police investigation is not related to a crime or the search for criminal evidence, such as finding an abandoned car or something like that. And then roadblocks, well, most often used would be sobriety checkpoints. And these are allowed because they're used for safety issues, for public safety relating to DUIs. Now, these checkpoints or roadblocks, if you will, they're not permissible for simply checking driver's licenses or outstanding warrants. Now, we can use them to question the public about recent crime, or looking for lost folks, or kidnapped or missing persons, or to pass out information. But no random stops if no suspicion of illegal activities. So we can't do like narcotics checkpoints. The courts have ruled those illegal. And then finally, here's the Michigan Department of State Police versus SITS. Now here, Michigan used random sobriety checkpoints to search for intoxicated drivers. And such stops in this case were upheld, again, as they were held constitutional because they advanced a substantial governmental interest, meaning the safety as it relates to arresting DUI drivers. And we should probably be done. So I'm not going to spend a lot of time on administrative searches. They're basically there to cover certain regulated industries and the need, and they need a statement of legislative purpose for search warrants. And there are 3 basic requirements. Regulatory scheme is supported by governmental interest. Warrantless inspections necessary to further that scheme. And then the statute limits official discretion and advises the owner of the limits. And there's a couple of cases that go with it. And I'm just going to kind of go through those a little bit quickly to end. So I'm not going to hit a lot on administrative searches because you don't run across those as much. I wanted to make sure that you were more informed on the other ones. Now again, because we jumped around a little bit, it's incumbent that you go back and look at the examples that are listed under each of the sections. So again, when we looked at things like vehicle searches, incident to arrest, well, if you go back and you look, underneath that subject will be a caption that says like right to search a vehicle as incident to arrest defined, and it will give you examples. So look at the examples, and they will help add context to a lot of the broader areas that we spoke of. So that's going to conclude our lecture for this evening. If you have any questions, feel free to post them on the discussion board. And if you don't want to post them there, then send me an email. And again, don't forget about the student resources that are located in your textbook. So with that being said, until next time.